Probably a lot of people here know that Aboriginal people are vastly overrepresented within both federal and provincial corrections. They comprise 20% of the total federal offender population, while being only 4% of the Canadian adult population. They are 1 in 5 new admissions to federal corrections, which is approximately 9 times the national average. And with respect to Aboriginal women, they are actually 1 in 3 federally incarcerated women, despite being approximately 2% of the Canadian adult population. In addition to that, Aboriginal people across the country are overall much younger, and they have a higher growth rate, so they're rapidly becoming a greater percentage of the Canadian population. Their overrepresentation within corrections is worsening. Statistics Canada projections to 2017 indicate that that will continue to grow, and particularly in the west and in the north. The offending circumstances of Aboriginal offenders often pertain to substance abuse, intergenerational abuse, residential schools, low levels of education, low income, low employment opportunities, and that's also related to general community and family breakdown that has been generated related to the impacts of colonialization and centuries of assimilation attempts. They also tend to be younger, to have served previous youth or adult sentences, have higher risk and need ratings when entering the correctional system, are more likely to have gang affiliations, health problems, and mental health problems, including fetal alcohol spectrum disorder. And I'm going to speak about that for a minute because I had a report come out for the Office of the Correctional Investigator last November on Aboriginal offenders in federal corrections. And what we found was that Correctional Services Canada has yet to introduce a fetal alcohol spectrum disorder screening protocol. So basically this illness results from a mother who has drank excessively during pregnancy, and there is basically a malfunctioning in the brain of the child that comes out of that. So it's a medical disability. There is something wrong, often cognitive deficits, sometimes a tendency to anger more easily. So now this is obviously an issue for all offenders within the system, but there is also a disproportionate representation, or so we believe, a disproportionate representation of Aboriginal offenders presenting with FASD. What this means is that often within the system they are actually overclassified, meaning they're more likely to be classified as maximum because of the characteristics of this illness. They're more likely to spend more time in segregation. Basically, it's more likely to be treated as a sort of aggravating factor when, if you really think about it being a mental disability, it's almost more of an ameliorating factor that requires special treatment and special rehabilitative programming. So basically, while those factors that I've just enumerated, you know, obviously they're much more than we can really expect the criminal justice and corrections system to resolve. Yet they have a unique role to play with providing specific interventions that you know, can help to ameliorate that situation. And in fact, the criminal code and subsequent case law has recognized the importance of restorative justice in lieu of prison time, particularly for Aboriginal offenders, and the need to take a culturally relevant sort of contextual approach to sentencing Aboriginal offenders. There is a similar provision also in the Youth Criminal Justice Act. So one of the reasons that conditional sentencing was enacted in 1995, which was a time of major sentencing reform, major sentencing reforms were enacted to the criminal code then, and I believe that sentencing had not really been reviewed within Canadian law and criminal code until this period. So this was a major movement towards looking at restorative justice and conditional sentencing. And one of the things that these changes arose from was a widespread concern about the overuse of incarceration to address crime, and particularly for Aboriginal people. So in fact, the Supreme Court of Canada has said that as a result of unique systemic and background factors, Aboriginal peoples are more adversely affected by incarceration and less likely to be rehabilitated by it. Imprisonment is often culturally inappropriate and facilitates further discrimination towards them in the justice system. So where am I going with this? Well, against that backdrop, we obviously have increased and new mandatory minimums that have either been passed or are pending in sentencing, reverse onus provisions, limits on credit for time served in remand, and changes to parole. Basically, what this adds up to is an expectation that, combined with the demographic projections of a young and growing Aboriginal population, a lack of prevention, i.e. addressing those sorts of factors before they even hit the system, and these changes to the criminal code, is we can expect an ongoing increase in the incarceration of Aboriginal peoples. So one of the things that has led me to do in my work is to look at some of the pending legislation and the acts that have been passed, and look at what is going to be the impact on Aboriginal offenders, Aboriginal communities, and frankly Canadian society, because it's not like we're not all sort of, we're all one society. You can't sort of hive that off. So a little bit more specifically, mandatory minimums and limits to conditional sentencing. Some of you may know that what has already been passed are new and increased mandatory minimums for firearms-related offenses and also for impaired driving. I have done some work in a book chapter doing a specific assessment of those sections and their impact on Aboriginal offenders. Pending are mandatory minimums for auto theft and trafficking in property, for drug offenses, and then there are also bills pending that will increase incarceration and limit conditional sentencing both for young offenders and for other offenses. So what happens with a mandatory minimum term, obviously, is that no conditional sentence is possible. Basically, it mandates the judge that regardless of the circumstances of this particular offense and this particular offender, they have to serve time. So basically, it removes all judicial discretion, despite the fact that they are the triers of fact. This is the role of judges, is to look at the conditions and the circumstances of each individual offender and offense. So there is a contradiction between the previous sections of the criminal code that provide for conditional sentencing and also what is section 718(2)E, which is the section that provides for avoiding incarceration for all people wherever possible, but particularly for Aboriginal offenders. That's obviously, and the accompanying case law, there's obviously a direct conflict between those provisions in the criminal code and the case law, and the movement right now to move towards more and more mandatory minimums, restrictions on conditional sentencing. And that's particularly in a context that is likely to impact Aboriginal peoples disproportionately. And the Canadian courts, Canadian legislators, the Canadian Human Rights Commission, and the United Nations all over the years have called on Canadians and the Canadian government to address the overrepresentation of Aboriginal peoples in the Canadian penal system. Nonetheless, these bills and acts will actually continue to feed that overrepresentation. And one of the areas of interest, I'm actually starting my Master's of Laws in the fall, and I'm going to be doing a thesis on Aboriginal people in the justice system. In the Aboriginal issues context, there's a lot of talk of reconciliation, both legally and from a sort of policy agenda perspective. So the reconciliation of Canada and the federal crown with the prior existence of Aboriginal peoples, and how do we sort of resolve a lot of the conflicts that have arisen. And that's often coming up in the area of land claims and self-government. But I started thinking about, well, how can we really talk about a reconciliation agenda when, if you accept that at least to some degree Aboriginal peoples are overrepresented in the system because of the history of colonization and assimilation attempts that have really been extremely destructive, how can we actually be talking about any kind of reconciliation agenda against that backdrop? So that's really just food for thought, and that's an area I'm planning to pursue in the fall. But basically, we can definitely expect that, given the status quo right now, that the overrepresentation of Aboriginal people will continue, much to the destruction of not only Aboriginal communities, but also detrimental impacts for Canadian society.